Welcome to another legal update from the Satanic Temple, where we tell you about the lawsuits we're undertaking and give you the updates and how they're going and how they're proceeding and playing out, sometimes forever. But first, we're going to talk about a couple tonight, but first, we're going to talk about our second Boston lawsuit to be distinguished from our first one, which is about legislative prayers put forward by the city council or before city council meetings in a public forum where we lost. They got away with claiming, I don't even know what they claimed, but ultimately they're allowed to give Christian prayers opening up city council meetings and denying everybody else. And unfortunately, we have the same judge in this one, and we don't feel that or at least I don't feel that the judge gave us the best chance or our best odds with our first case. But hopefully this one will be different. All we can do is plod forward. But in the case here, uh, up until 2022, Boston allowed any member of the public to apply to fly a flag at the city hall. And in May of 2022, the United States Supreme Court ruled that Boston's flagpole practice constituted a public forum, meaning that government viewpoint discrimination regarding any flag's messaging is unconstitutional. And this came about because a Christian group applied to fly a Christian flag, and the Supreme Court said that due to Boston's policy, they were obligated to fly that flag. So the Christians put up their flag, and we immediately applied to fly our own flag as well. The policy hadn't changed in a bit. Nothing had changed. The Christian flag was up. The Supreme Court had ruled that they needed to accept this type of flag. They couldn't discriminate against religion and certainly not against particular religions. But nonetheless, that's what Boston decided to do. After losing in the Supreme Court, they decided nonetheless to say, no, we're not going to fly the Satanic Temple's flag. And then they changed their policy. And I think that their argument is going to hinge on changes they made after the fact, but you can't apply things retroactively. Fact of the matter is they had a policy that the Supreme Court found allowed for these flags to fly, and they decided they would act upon that ruling insofar as the Christian flag was concerned, and it did fly for a day or for whatever number of hours it was allowed. And they simply said no to the Satanic Temple, which is something Boston is in the habit of doing whatever they want, and there seems to be little consequence for them, as we saw when we went to court the first time. However, as is typical with these cases, we filed our complaint, our suit, and the other side motioned to have it dismissed on several counts, and I'm not sure what the several counts were, but we withstood all of them, and the judge said the case may move forward. Usually, that's not something to get excited about necessarily, I don't think, because that's standard practice. But in this case, it seems a little different, at least to me, and I'll let the lawyers chime in if they feel differently. But it feels different because what the judge is saying is that if the facts as presented by us remain the same throughout the litigation process and no new evidence is brought to bear, then we have a credible complaint of discrimination. And it's really hard to see how all the facts aren't laid bare in the complaint that we put forward or what they could possibly bring into evidence to mitigate them. It doesn't seem like there's much at dispute here. The Supreme Court, as I said, ruled on the side of flying these flags. Boston just ignored that in our case, and it seems so straightforward and cut and dry that if the judge sees that we could have a legitimate complaint of discrimination here, it just doesn't seem that there's anything that would mitigate that. But I will let Matt address what were what on what grounds was Boston trying to get the case dismissed to begin with, and do you think that this is grounds for a certain amount of optimism on our part?
Sure. Well, let's start with the text of the order, which I think is helpful. Um, yeah, that's it. So here we have the salient part of it. The first paragraph is this is the entire order, by the way. The first part of it basically just says these are the claims that we brought. The second paragraph says we sued Wu in her official capacity alongside Boston, and that's duplicative. So Wu herself is dismissed,
Wu
although
is
it's
Michelle Wu is the
Wu.
mayor of Boston.
Correct. Yeah. So part of our complaint was that under this new policy that they have, you either need to have a mayoral proclamation that you can fly the flag, or you need to have a city council resolution that you can fly the flag, but you need one or the other. So our contention was, well, we need to sue Wu because if we're going to get an injunction, it has to be a person has to be enjoined. You can't enjoin the city. In my understanding, you have to enjoin a person. So we sue Wu. Judge says, well, you can. I mean, I'm reading between the lines here. Judge says you can actually get an injunction against the government itself, not necessarily just the city. So Wu's unnecessary. She's out. The remainder is the part where they basically say everything that we claimed is properly pled, which kind of goes to the order of operations in civil litigation. Plaintiff files a complaint, defendant files a motion to dismiss, says you didn't plead sufficient facts that a court can find it plausible that the plaintiff is entitled to the relief they're seeking. Judge assesses whether there are sufficient facts to make it plausible. Sufficient facts taken as true that it is plausible. My complaint was very, very particular. I looked through everything in advance of putting it together, so I'm certain that all the things that we said in there are true. Um, so to your point, is this grounds for optimism? I think so. I mean, our claims to recap was free speech, it's viewpoint discrimination to let in the Christian flag but exclude the satanic flag, free exercise, which is basically the same thing, and establishment clause, which is you can't have preference for Christians. So all three of those were pretty much all saying the same thing with different parts of the First Amendment. The last one was this Freedom of Information Act. And to recap on that, in advance of bringing the suit, I issued a Freedom of Information Act request for various documents pertaining to all these flags that are getting flown, any applications they're on, etc. They said we don't have anything. Well, we knew that there was at least one application, which was ours. So when they file their motion to dismiss, they say, oh, look, here's all the stuff that they were looking for, which in our response, we basically just said, look, the fact that there are these documents out there means they understood what we were looking for and they chose to not give them to us. That's grounds for liability. So that's kind of the brief recap of what was held and why it was held. The salient point is down here on this third paragraph. It says, TST plausibly alleged that in the days following the shirtlift opinion, raising a flag on the Boston City flagpole remained public expression, not government speech. TST also plausibly alleges that the city did not fly TST's flag because of TST's values or views, and that the city showed a preference for the Christian group over TST, and that the city closed their flagpole to stop expression of disapproved viewpoints. Finally, TST properly alleged that the city did not provide them with documents to which they were entitled under Massachusetts Freedom of Information Act. Accordingly, the city's motion to dismiss all claims under 12b-6 is denied. Rule 12b-6 is you fail to plead sufficient facts. So
And
that's
let me interject and let people know that shirtlift is the Supreme Court decision that went in favor of the Christians being able to fly their flag.
correct. So that's pretty much the long and short of it. I mean, essentially the judge's opinion is on facts given, smells like a good First Amendment case to me. The city's primary point that I was a little bit concerned about is essentially that the Supreme Court invited them to change their policy, and they did. Well, our response to that is, well, you didn't change your policy until after we put in our application, and the fact that you were still taking applications means you were still open applications. It was still open season for whoever wanted their flagpole up. So perhaps the facts will look differently after discovery, but on the facts that are that I'm privy to, everything looks good to me.
Could the facts look different on discovery? Because I feel like if they were even in the process of changing the policy in any substantial way, we would already have those documents by now, would we not?
One would think, but I don't know what they're going to say or do. I mean, hell, at the close of motion to dismiss in Boston one, I was feeling good too, but then we saw how that turned out. So I remain open to being surprised, is all I'll say to that.
Stu, how do they rule against us?
So first I'll say that it is very promising. I think whenever plaintiff overcomes a summary judgment motion, that's kind of the first line of defense, right? They say basically even if everything you said is true, you can't prove this case. So the basically what the judge is saying here is, hey, if everything you're saying is true, you do have a colorable claim. Now, this is similar in that in what happened in Phoenix, not Scottsdale. To distinguish those, we never filed suit in Phoenix because and you actually can see the clip if you've seen the Hail Satan documentary. There's a clip where the city attorney of Phoenix at the time says, we cannot change a policy retroactively. That would be illegal discrimination." So we ended up not suing them because they removed the entire program to avoid suit. Could we still have? Probably, but at the time, that's not the decision that we made. But the point is these city attorneys realize they can't do that constitutionally. So the fact that they did change this retroactively to the point where a suit was filed, and then we overcame summary judgment, it looks like that's a good sign for the case. Now, how do we lose? Well, things do happen in discovery, which that happened to us in Scottsdale, where after a ton of brouhaha, as the judge actually used that term, where there was a ton of public commentary by the legislators about why they wanted to remove us from the public forum because we're evil, and they're not going to stand for this in their town. Well, once we started doing discovery, immediately we found out that none of this was discussed in a legislative setting, and eventually I think that partially cost us the case, and that they decided it was an administrative decision made by a different city bureaucrat that wasn't in the legislative session. Therefore, sometimes things do change in discovery, which is one of the difficult things in litigation is as the facts come out, it's unpredictable. So I couldn't say how we lose. This one seems like a pretty solid case, but we've been surprised before.
Well, what's next? We should be moving into discovery fairly soon, shouldn't we? And this is when we uh, depose people, take their testimony, and figure out the facts that are actually being argued here, and we get all the evidence in place, and then discovery is closed. We can submit no more. We bring it to the court, and that's that. When does that process start? And what do we really get from discovery at this point? I remember I think we had this conversation last week, Matt. I was wondering what could Boston even ask of us in this case? I can't imagine uh, giving any relevant testimony to this that isn't already on the record. It's such a basic case, is what I'm saying. Doesn't seem like there's many mitigating characteristics to this that could be revealed through deep interrogation of either party.
I predict that they probably won't even ask for any depositions from us. Maybe things will be different this go around, but last go around, as I best recall, they didn't ask anyone anything. Their whole defense was we can do it if we feel like it. And again, it turns out they were right. So I would not be surprised to see that they don't contest the issue that we, in fact, issued an application um, on the date and time that we said we did, because I mean, that's really all there is to it from our factual predicate. The information that we need is really from them. I personally am going to want all of the applications that have ever been received under that platform going back to, I don't know, probably about the date and time, at least as far back as the Shirtlift group put in their request, possibly even further. I'm probably going to want all the discovery that was exchanged in the Shirtlift case, so that in case it's still a, live factual controversy, whether or not this was a public forum, which is more a fact question than a legal one. But basically, I'm going to take a look at the Sherlock opinion and see what all evidence did the Supreme Court rely on there, and basically say, well, your website says it's open season for anyone. So what was your archived website looking like on the date and time of the application? So these are all things that I want from them. As to when does it start, our 26F meeting, which is the formal meeting that attorneys take. Basically, it's a meet and confer. You call up the other side and say, hey, how long do you think you need for discovery? miscellaneous other questions to that effect. We are to meet no later than March 3rd, and on March 10th, unless we have a scheduling order the judge wants to talk about, there's a scheduling conference set for March 10th at 11 by Zoom, or such other remote proceedings. So sometime shortly after March 10th, discovery will formally kick off. I'll issue our written requests, and we'll see what shakes out.
All right. Well, there's that. And also last week we went to the appeals court, Second Circuit in New York City, Manhattan Court, for our appeal in our case against Newsweek. And in case people don't know about that, in October of 2021, Newsweek published a hit piece against the Satanic Temple, alleging that there's sexual abuse and cover-up, amongst other crimes, committed by the Satanic Temple. And this was all based on hearsay, several times removed from people that were dug up specifically for the purpose of writing a hit piece against us by a woman who wrote books on abstinence only, a real zealous Christian who apparently was tipped off to write a negative story about us based on internet hearsay against us by somebody from the Catholic News Agency, I believe it was, or Catholic News Service, reached out to this gullible woman who wrote for Newsweek. I don't know if she does anymore, but she put together this piece and reached out to people who online have made a habit of attacking us with slanderous statements, and then reported them in Newsweek as though they were fact. And we sued for defamation. These are very harmful claims against us, and none of them true. And the disappointing part about the fact that we lost the first round is that it was not at all a question of whether the claims they were making were factual. It became this legal standard of whether or not the reporting of it was actual malice. Because when we went through and did our depositions in discovery for Newsweek, the witnesses who made these claims that were published by Newsweek openly admitted that they had no basis for making these claims to begin with, that they were themselves basing what they said upon hearsay and internet rumors, and then reporting those as though they had seen them directly. And one of the deponents, one of the witnesses, Paul Millerons, aka Jinx Strange, had said in the piece that these were that he had receipts, that these claims were more than anecdotal. So implying that he had seen these things. Yet in his deposition, Matt asked, okay, is it fair to say your understanding of sexual abuse was secondhand through people basically telling you something over the internet? And he said, yes. There were two other witnesses making these claims. One was a Nathan Sullivan, who was asked, and you personally did not see any of the sexual harassment, correct? And he said, correct. And then there was David Allen Johnson, who said, okay, have you personally witnessed any sexual abuse within the Satanic Temple? And he said, I have not. So not only did they not speak to anybody who had any actual contact with anybody who would credibly make these claims or produce any evidence of them, they talked also, the journalist actually talked to me, talked to Professor Joe Laycock out of Texas, who wrote a book about us, and she didn't ask us about these accusations at all. And yet they used this idea that they interviewed a multitude of people to support this claim that they did research, in fact, about these things, and they did their due diligence. And I guess there's a dispute here. We'll listen to the recording of the court proceeding about industry standards versus the paper's own standards. But Newsweek publishes on their site, I don't know if they do anymore, but they did at the point where they published this article, these standards of reporting that say that specifically that they do follow up on these kinds of things, that they do have a policy of not just publishing hearsay or salacious accusations against people without doing this kind of due diligence and follow-up research, none of which happened in our case. So we felt like in the context of them saying they have these publication standards in and not exercising any of them in the case where somebody obviously with an axe to grind against the Satanic Temple writes an article against us that makes all these accusations that they were very much remiss, but they were also signaling to people that they had done this kind of work, that they had done this research, that they had credible reason to believe that these accusations against us were true and not just some hack cultivating people they found online who were willing to say rotten things about us and then publishing them, which is exactly what happened. But I think what you would find infuriating is how hostile the judges are, it seems, to litigating the question of whether this is factual at all. It's funny to see an argument like this move right beyond whether it's true or false and into these legal standards. I guess that's just how it goes in these kinds of cases. But the swiftness with which that was declared absolutely irrelevant, whether they were entirely lying or not, seemed to be discarded entirely. And the case ended up kind of hinging on that one sentence, right? Where Paul Millerons there said that he had these cases that were more than anecdotal and he had receipts on them. And there was none of that follow-up whatsoever. And they made various other false claims against us that were also reported in the paper. But I guess that was ultimately what the courts were interested in because that, and correct me if I'm wrong, but that was the line that indicated that there was something that could have been followed up on and that something was, that a comment was being made that made it clear that these weren't just subjective impressions or somebody just believed these things as a matter of opinion, but that there was evidence to bear on the situation that in fact also wasn't there. Is that the case? Is that why that particular quote in the piece was so important to the judges to the point where they ignored pretty much everything else?
No, the reason why that was important is because when you sue for defamation, you can't sue because someone wrote a hit piece about you. You have to sue because they made a specific charge that was false and defamatory. And charge is the legal jargon term for the defamatory statement. And when I say defamatory, what I mean is it has a likelihood of harming someone's character and is actionable consistent with the First Amendment, meaning I can't, as a general proposition, sue someone because of an opinion, or at least a pure opinion. You have to sue over something that is fundamentally factual, something that can be disproven. So, for example, the classic one is Nazi. You can't sue someone because they call you a Nazi as a general proposition because it's just like a hyperbolic statement that people say sometimes, or frankly, very often. So we raised issues about a lot of statements within the hit piece, but the judge kicked out all but this one. So early on in the oral argument, when they're narrowing in on and they're saying, okay, it's just this one sentence, right? They're basically shutting the doors on me saying, oh, well, actually, I take issue that the judge dismissed 12b-6 on this accusation of financial misfeasance over here, or this other accusation over here, that we lie about our ritual activity for purposes of litigation efforts. All of those, I think, are clearly false and defamatory, but I wanted to pick the ground that I felt had basically the most ground to give, which is actual malice. I think it's also important to note that we were not held to the actual malice standard because we're a public figure, which is the ordinary course. Rather, we were held to the actual malice standard because the New York statute says even if it's a private figure that the statement is about, if it's on a matter of public concern, then the private figure plaintiff has to prove actual malice, which I think is an egregious standard for a public policy reasons, but not the New York legislature. So we are arguing it's not a matter of public concern to accuse someone of sex abuse and cover-up, albeit falsely. But that's what the district court found. District court found that any accusation of sex abuse and cover-up per se is a matter of public concern.
So we have a journalist who was tipped off by some Catholic news service or whatever to write a negative article about us that people were saying negative things. She collects all kinds of negative commentary against us, refuses to do any further research, but to even when offered, even when these witnesses who lie about having receipts, offer them, she doesn't even try to get evidence to support her claim. And then she interviews me, and she asked all about the financial structure of the Satanic Temple because apparently she thought that's where she was going to find some wrongdoing, but there isn't any. I explained the whole structure to her. She was disappointed, so she moved on to something else. Never allowed us to address any of the other concerns, and then publishes this piece that says nothing nice about us for sure, and arguably many a damaging thing. What would establish actual malice in this case? What could we possibly do to show that this is actual malice, meaning, well, whatever it means by the court standards, but I would think it would mean that she intentionally published a negative piece against us and the evidence be damned.
That's more or less what actual malice means. And the legal jargon phrase is that you were reckless as to the truth of the charge. And that's a very slippery standard, which is why we were up on appeal. The cases that we rely on primarily essentially say if you're avoiding the truth, then that's actual malice. That's proof that you have subjective doubts in your mind about whether the charge is true, and you are actively avoiding information that would tend to prove or disprove the truth of the charge. There's a couple of cases that we repeatedly rely on. There's one called Butts and another one called Hart-Hanks. Butts was not an actual malice case. That was on a different standard. But Hart-Hanks says, basically, they point to Butts and say, look, this case is factually indistinguishable. And I don't remember the verbatim, but it was essentially, it is easily sufficient. Let's see, I actually have it up. Unmistakably sufficient to support a finding of actual malice. And in both those two cases, you basically have the same thing as you have here, which is a hearsay claim, an offer of proof, and the reporter declines to look into that proof. That's the fundamental basics of what we have here. We are adding on this argument that, Newsweek's own standards indicate that they doubt these kinds of claims. When Newsweek's editor-in-chief testifies, yeah, this kind of claim needed to be factually investigated. It was my job to do that factual investigation. I did not ask whether there was a factual investigation. These important admissions are what we primarily rely on to say, look, they clearly doubted it. It's up to the jury as to whether or not they had doubts in their mind. They don't get to say, oh, well, I believed it, and that's the end of it. If my own policies say I'm supposed to factually investigate something and I choose not to, that's actual malice within the meaning of Hart-Hanks and Butts.
Right. Well, I think it's worth reading because I have it open here, but you also deposed Nancy Cooper, the global editor-in-chief at Newsweek. And she was the one working directly with the journalist whose name was Julia Dean, spelled D-U-I-N. But you asked, Julia Dean wrote articles for Newsweek, correct? And you asked this of Nancy Cooper, and she said, yes. Did you fact check anything in the articles? No, I raised questions to her, but I didn't personally fact check things. Did Julia fact check anything? I don't believe so. And we're not talking just this article, we're talking overall. As I can recall, yes to what you're saying. Did anyone else over Julia Dean's entire career at Newsweek fact check any of her articles? I don't believe so. I mean, that's the testimony we're given, and that's the quality of research that is put forward in order to disparage us in the way that they did. And to be clear, like, it's kind of remarkable over this over 10-year period how little we've had in the way of interpersonal disputes within the organization regarding claims of sexual abuse or sexual harassment. Of course, we have, committees, personnel, and things like that to deal with that kind of thing. But there's been very little, and certainly if there's ever been a case, there has been no cover up of any type. So I think they were a bit shocked going into discovery themselves, thinking that incidentally they would find a bunch of things that they could point to because who doesn't have it? We really didn't have that either. I remember my deposition was really quite short, and then it seemed to be a big disappointment to everybody because there just wasn't that kind of info there. So we came out, we feel like our name's cleared, but the case lost, and it's infuriating. But you have the audio from the appeal, and we were going to go through that, so we might as
Yeah,
well get
and
it started.
to emphasize, this is just the oral argument. The whole appeal is the brief. That's really where you get into the nitty-gritty of this is what the deposition testimony was and all of that. Here are all the points, but let's see if I can share. All right.
When you're ready, you may proceed.
Thank you, Your Honors, and may it please the Court. My name is Matt Kazai. I'm appearing on behalf of the appellant, the Satanic Temple. At issue is a question of actual malice, an issue which does not readily lend itself to summary disposition. A jury could find that Newsweek was reckless as to the truth or falsity of a charge, that TST engages in sexual abuse and cover-up. The district court erred by requiring
I'm
direct...
sorry, you said reckless?
Reckless
As
disregard
to-
of the truth or falsity of the charge that TST, in fact, engages in sex abuse and cover-up. The district court erred by requiring direct proof of doubt, by assessing the inferential grounds for doubt piecemeal instead of collectively, and by failing to address all evidence which would support an inference of actual malice.
What do you point to as the best evidence in the record that they had any serious doubts to the veracity?
There are three grounds that we primarily rely on without waiving anything within the briefs. Number one, the charge asserted a sexual crime. It was undisputed below that sex abuse and cover-up would be sexually criminal activity. Number two, it was conveyed by a source with known hostility to TST. And number three, that source disclaimed personal knowledge of the truth of the matter asserted, whether TST in fact engages in sex abuse and cover-up. The way it's phrased in the article is that leaked materials show accounts of sex abuse and cover-up in ways which are more than anecdotal. Each of those three grounds asserted in the article are there to provide substantiation and lead a reader to infer that, in fact, TST engages in sex abuse and cover-up, a matter which is false. Opposing counsel in their response claims it is, in fact, true that there are, in fact, rumors that TST engages in sex abuse and cover-up. Our problem with that is twofold. Number one, it's barred by the republishing rule. The republishing rule posits...
I'll briefly pause there. One of the main points on the appeal when mooting this case that gave me a lot of pause is a lot of the attorneys that are helping me on a voluntary basis kind of picked up on this notion of, oh, well, Jinx Strange did actually say that there are rumors, and in fact there are rumors, therefore it's not actually false what the article says, which is that there are rumors. The court incidentally bite on that argument. That was, if there's any reason why we lose case, because the court basically says we're going to pick up on that, notwithstanding that well-settled law says that's a stupid ass argument. So that's essentially what I'm starting off right out the gate, about 2 minutes into the oral argument, to knock that out of the park. And I'm actually very happy.
So they're saying they're reporting on rumors, and they're saying they're rumors, but we're pointing out that they are essentially saying that there is evidence that this is true. No,
what they're saying is technically we reported on the fact of rumors, not the assertion underpinning the rumors that TST engages in sex abuse and cover-up. We're just saying people say they do. And that's been it's called the republishing rule. And for decades now, that's just not been a defense. You can't say, oh, well, I'm just reporting on the rumors. If you're reporting on the rumors, you're reporting on the facts of the rumors, the underpinning of the facts. And so
I don't
that's what
understand how they get such a how how this is even a thing at this point. Who can, if you take something like the Satanic Temple and the magnitude at which we operate, meaning so many people are exposed to the Satan, there's a lot of dialogue about our activities, positive, negative. There's a lot of people with opinions. There's, of course, going to be a lot of rumors and hearsay, especially about the Satanic Temple. There's going to be people claiming we do things that we don't, things like that. I mean, anybody could do this. Anybody could do this to any organization of sufficient size. Find the people who are saying negative shit and then publish it like this as though it were fact. It's not. This certainly isn't a matter just for the Satanic Temple. I think it's a matter of general public importance that this not be made the standard, that you can just do a search to find anything negative about something and then about somebody and then say like, well, I'm not saying it directly. I've just kind of compiled this from, whatever wild asshole on the internet has an axe to grind, and that provides cover for them. It seems crazy to me.
Well, it pretty well is. I mean, those three facts that I started out with of it, their own, I mean, they drill into it a little bit here, but their own standards say if someone's accusing someone of a crime, we better look into that before we publish it. When your own standards say you better look into it, that has a tendency to prove that you believe that there's a credible chance that that might not be true in the
But
specific.
they don't say we should look into it. They say we do. And that to
No,
me
they said we
is
must. We are
okay,
required to.
right. Okay. But that indicates that they do, and that
Yeah.
if they publish such a thing, that you can believe there's better grounds for believing it than simply saw a guy who was pissed off on the internet, gave him a call, and he said the same things he was saying online.
Yeah, well, that would be in my opinion, maybe the Second Circuit will correct my opinion here in a few months, but in my opinion, that is actual malice. And again, we cited
I just
those
don't
Supreme
see
Court
how it
cases.
isn't. This one gets me a bit animated because it pisses me off so bad.
Well, rightly so. But I did want to drill into that republishing rule point because that might go over
That you
people's
can't,
heads.
as a publication, simply republish someone else's libel, point to who stated the libel, and disclaim whether or not it is true.
Are you on falsity?
This is the issue of falsity, yes,
Okay,
Your Honor.
so, yeah.
So-
You've moved away from actual malice and you're talking falsity?
Yes, Your Honor, I took a moment to segue. Going back to the issue of falsity, those three grounds made it obvious that there was a risk that this claim was false.
Can I just make sure that we're on the same page about the claim? After the motion to dismiss, not the personal jurisdiction, the 12b-6, what is left on appeal here is a single statement that I have as, quote, accounts of sexual abuse being covered up in ways that were more than anecdotal. That is the only statement, right, that we're talking about?
The entire paragraph must be read to make sense of that sentence.
There's context, but that
Correct.
reading of the district court's dismissal, that's the statement the district court allowed to go forward to summary judgment, right?
That is the article statement, but it is our strenuous proposition that the preceding sentence, which says he was leaked materials, that must be read in conjunction with what is termed the article statement. So the charge is sex
Okay,
abuse and
so
health.
let me just make sure that I'm clear. But that is the only statement on which we're proceeding. There's no challenge to the dismissal of the complaint as to the other statements that were originally alleged, right?
Correct.
Okay.
Yes, Your Honor. Our focus is on the specific charge, sex abuse and cover-up.
Well, except the specific charge is accounts of sexual abuse being covered up.
Correct.
Okay.
Which is why I briefly segued over to the issue of falsity, because that is, in fact, what Strange said. However, that argument is, in fact, barred by the republishing rule. New York law, as we cited to Bureau versus Condé Nast in the reply brief at page 10, New York law has expressly rejected that as a proposition for a defense. You cannot survive liability by simply saying, I heard from Gene Strange that there are accounts of sex abuse and cover-up being ways more than anecdotal. The heart of that charge is false. The heart of that charge is defamatory. And the heart of that charge had facts that Newsweek was aware of, which would have put any actor in the situation of Newsweek on notice that that was false. Again, those three facts that we primarily rely on are it asserted sexual criminality, it was conveyed by a source with hostility to TST, and he disclaimed personal knowledge of it. I sense the court's about to ask a question.
The first point you're making, about criminality, can you elaborate?
Yes, Your Honor. New York law connotes a duty to investigate when you are accusing someone of criminal activity. The charge at issue, it was undisputed by both the reporter and the editor. This charge connotes sexual criminality. It is sexually criminal to engage in sex abuse. Sex abuse is the material aspect of this that we're taking issue with. The cover-up as well, but sex abuse and cover-up, they specifically admitted that sex abuse would be a crime. Cover-up as well, the editor, but not the reporter, admitted would be a crime. Now, the reason why I keep emphasizing the facts that would give rise to the obvious grounds for doubt is that's what triggers our duty to investigate. Strange's email opened with and closed with an offer of proof. Duane did not take him up on that. She didn't so much as ask anyone on the face of the planet what sex abuse and cover-up even means in context of this quote. And all of this fits within the restatement of torts definition of recklessness, which we provided in the 28J letter, that when you have awareness of facts that would give rise to obvious doubt and you don't take any precaution in this case to ascertain whether or not that is true, that is actual malice. And the best case we have on point for that is Butts, and also this case King, in which essentially it's the same thing. I heard that such and such happened, and they didn't talk to anyone who actually knew that such and such happened. Reliance on hearsay is obvious grounds for doubt.
Let me
other questions, reserve the rest for rebuttal.
Can you pause it for a moment?
Yeah.
I wanted to ask, because this is something I didn't pick up on when we were in court, or it's something I didn't think too deeply about. But you said she didn't even ask what constituted sexual abuse in this context, which, I mean, it goes deeper than that. Like, at first, I think when I heard that, I was just thinking of legal standards of what constitutes sexual abuse, but it's worse than that. She doesn't even know the who, what, when, why, or where. She just knows there's an accusation. There's no incident that this is even tied to. She's not told that somebody in particular was abused in a particular way, right? Like, for all she knows, somebody's standards of sexual abuse might have been an off-color comment, and she didn't bother to get any elaboration. Is there any consideration on the side of the court or the side of the law for the fact that she was reporting on something that she only had, what would you say, like a surface description of, without something to attach that description to?
Right. So this is the slippery argument that is actual malice. Inept reporting is not actual malice. We have to show a conscious avoidance of the truth. That's why I'm emphasizing, and that conscious avoidance is triggered when there are obvious grounds for doubt. So, for example, when you have someone with who's a hostile source who's peddling hearsay claims, case law tells us that's obvious grounds for doubt. That's not, a mere subject of inept reporting. Oh, they should have looked into it more, or what have you. You needed to look into that at all. And so that's really what I'm really emphasizing there. This anyone on the face of the planet business came up at the tail end of a cross-examination, which I'm drilling her on. Well, who'd you talk to? Did you talk to anyone who was allegedly abused? No. Did you, take him up on his offer of proof? No. Did you ask anyone at all what this means? Anyone on the face of the planet? I said, yeah, we'll ask that question. Have you asked anyone on the face of the planet what sex abuse and cover-up even means in context of this here charge? She said, no. Didn't even ask. No follow-ups whatsoever. And so that's what we're really drilling in on this appeal, which is it's not just that she's inept. It's not just that she failed to apply someone else's standards. This will come up again later. It's that her own standard said she had to investigate, and she didn't. We posit that that's a conscious avoidance of the truth. That's actual malice. But it all is hinging on this notion that there were obvious grounds for doubt, grounds that any reporter in her situation would have said, I feel like that might not be true. Maybe I should look into that.
Right.
Okay, thank you. You do have 3 minutes for rebuttal. We'll hear from Counsel Stracker. Is that right?
Good afternoon, Your Honors. My name is Cameron Strucker. I represent Defendant Newsweek in this matter. Your Honors, I'm not going to talk about the truth of the statements at issue here. I think that that's been fully briefed in our papers, and we will stand by those arguments. I would like to talk momentarily about the standard of recklessness. Recklessness means a subjective awareness of probable falsity. It means that the declarant, the speaker, the person making the statement has knowledge of something that would cause them to look and discover falsity. When you look at the classic recklessness cases, like the Connaughton case, those are cases in which there's information provided to the speaker, like a tape, on which if the person had listened to the tape, they would have heard things on the tape that would have led them to conclude that what they were publishing was false. There is nothing in the record that is analogous at all to those facts, to the facts of Connaughton or the facts of Butts or the facts of any of the other recklessness cases we've cited in our brief. I heard counsel talk about that this was a sex crime and that the declarant had hostility and that the declarant disclaimed personal knowledge. But none of those are facts that would cause the speaker to have a subjective awareness of the probable falsity of the statements that the speaker is making. None of that is like a tape where there are other statements on the tape that can turn the speaker around and make the speaker realize that there is falsity that the speaker is about to publish. And by the way, the Butts case, which appellant has just cited, that's not even an actual malice case. The Supreme Court essentially rejected that holding, which was a holding on essentially what is gross negligence. The Supreme Court rejected the holding of Butts in the Rosenblatt case and subsequently in the Gertz case, and then thereafter in the Connaughton case. That is not an actual malice case. Actual malice means subjective awareness of probable falsity. And I will say that there's nothing on the record that smacks at all of subjective awareness of probable falsity. If the court has no specific questions for me, I think it's worth concluding with a sentence from the court's decision below. The court concludes by saying, here, similar to Brimelow, and unlike the record in Hart-Hanks, there is limited evidence of potential departures from professional standards, there is sparse evidence of bias, and there is a total lack of any evidence that Dean, the reporter, harbored any serious uncertainties or had any obvious reasons to doubt the truth of the article statement. That was the well-founded reasoning of the court below, and I would urge this court to affirm it.
Can I ask about the personal jurisdiction?
Yes.
With respect to Dune?
Dean, Ms. Dean.
Dean. I guess it's hard to find cases sort of exactly like it. And I'm just wondering your understanding of the record with respect to how much of the article is produced and edited in between her and the editor in I presume in the headquarters in New York.
I'll pause there to give some exposition. The reporter's a Washington resident. We sued in New York. Under New York law, they make it very difficult to sue for defamation out-of-state defendants in New York, out-of-state being, in this case, someone from Washington. We have to show that there was a course of business that the reporter was engaged in, and the defamation arose from that course of business. Um, it's our position that and certainly it was our position in the complaint that the reporter was full-time employed by Newsweek. Newsweek responded with an affidavit that says she's not employed by us, she's an independent contractor. Judge said, well, independent contractor or employer aside, it doesn't matter because even if she is an employee, that's not enough. So that's part of our appeal, is that she should have been a co-defendant in this case all along. So if the court does reverse and remand for a jury trial, then she's got to be sitting in the defense chair. She's not just some disinterested witness. So
Well,
that's what this
Mr.
question is
Stracker spoke fairly briefly and just kind of focused on one thing, the idea that there was no disconfirming evidence of the claims that the journalist had seen that would make her think that this was false. But this seems to be leaning really heavy on the fact that she refused to do any background investigation at all, even when things were offered to her. It seemed really bizarre to me at first that he cited this idea of a tape that could have disconfirming evidence when you have somebody saying, I've got receipts, and her not bothering to follow up, not bothering to talk to anybody else, not bothering to ask the names, anything about the identity of any of the people who supposedly would have suffered any of these things at our hands. It just feels like there could have been, somebody could have said there's a tape, but she would have been okay if she had just ignored that fact and not bothered to listen to it.
I'll weigh in on that a little bit because in criminal law, there's a lot of arguments that happen routinely about the difference between recklessness and negligence. And to me, what this sounds like is that's what the defense is trying to claim here. It says, okay, well, perhaps what she did was negligent, which is basically she didn't do something she should have done out of her own ignorance. But in recklessness, it's knowing, it's evidence that you knew that you should have done that, and you chose not to intentionally. So what he's trying to do is distinguish by saying in these other cases, there was dispositive evidence. There was evidence that said, someone said, hey, this might be wrong. And you just said, I'm not going to listen to it. So that, I think that's what he's trying to do is say, okay, well, maybe it's negligent, but it doesn't rise to the level of recklessness because there's not evidence to show that. When really, I think this comes down to that they have a higher standard. I mean, they even have internal policies that you should not publish something that's not fact checked, which, I would say is reckless.
Well, the infuriating part about this is then you get a ruling where the court is like, well, it's not exactly reckless, but it is negligent, therefore you lose. And like the broad population who only sees the surface of this, they're like, oh, they lost when they sued for defamation. The claims against them must be true.
Well, yeah, and cases hinge on the difference between negligence and reckless and intentional. All these concepts, cases win or lose on those grounds all the time. So I think to try to mitigate and say, well, it maybe wasn't right, but it wasn't reckless. I think that's probably, the defense that's often used in these type of cases.
It's unsurprising as a lawyer to hear a defamation defense be not necessarily, oh, well, it's true or substantially true, but more so, well, I didn't know it. You can't prove I knew it more accurately. But that's not recklessness. Knowledge is affirmative knowledge. That's the difference and I don't interpret what Cameron's saying here as saying you have to prove direct knowledge. What he's saying, as I understand it from my interpretation of the cases, is that in these other cases, the source offered up or otherwise the proof was made available that would have shown that it's false, and no one did that here. But that's why on rebuttal, one of the first things I'm going to say is, no, he opened up his email with an offer of what he called the receipts, and he closed with an offer to go gather more proof. That proof was made available to Dean. She chose not to take him up on it. That's conscious avoidance of the truth.
The record is that she wrote the article and that Nancy Cooper, the editor, did a light edit of it.
And she's in New York.
She's in New York.
And the article's produced and published out of New York?
I think it's fair to say that, I mean, the servers are not located in New York, but Newsweek is a New York located company. So if you want to say that the article was published in New York, we wouldn't contest that. I think it's important to note, though, that the reporters in Washington State, the controversy involves a Washington State lawsuit between Washington residents and a Massachusetts corporation. There's no reference to New York at all in the article. The article has nothing to do with New York. The words New York are not even mentioned. No witnesses are interviewed in New York. No information comes from New York. The only connection to New York is that the company is located in New York. And that's not enough for personal jurisdiction. If Ms. June did
exactly what she did here, but did it in New York, would you contest personal jurisdiction? Ms. Dean, I'm sorry.
No, even that would not be enough because the test under the New York statute is that there has to be a transaction of business in New York, and the tort has to arise out of that transaction of business. And typically, when courts look at the transaction of business, they look to see what did the reporter do in New York? Did the reporter do any reporting in New York? Was the subject located in New York? Now, if the plaintiff was located in New York, that might be a closer case. Or if there were witnesses and informants located in New York that the reporter talked to, that might be a closer case. If the events that the article was talking about was in New York, that might be a closer case. But here we have none of those factors.
Procedural question. She's presumably dismissed without prejudice for lack of personal jurisdiction, right?
Yes, I presume that, yes.
A dismissal without prejudice means that the lawsuit can be refiled.
Wrong on that, but otherwise prevail, it would be a dismissal with prejudice, wouldn't it?
Yes, well, the case would be dismissed with prejudice, and presumably she would have a collateral estoppel or res judicata defense should they try to sue her again in Washington State.
You're saying even without prejudice?
If her dismissal on personal jurisdiction was without prejudice?
Which presumably it was.
Right. But if this court were to then affirm the decision on the merits, they could sue her again in Washington State, but I would assume that this decision would act as res judicata or collateral estoppel against any lawsuit that would be brought against her in Washington State.
Okay. Thank you.
Thank you.
Judge Cabranes, any questions?
No, not at all. Thank you.
Okay.
Thank you.
Rebuttal for 3 minutes, counsel.
I'd like to seize on this notion that Hart-Hanks is different because Strange did not offer any substantiating proof.
Cameron referred to Hart-Hanks as Connaughton. The full case name is Hart-Hanks Communications, Inc. versus Connaughton. I call it Hart-Hanks. He calls it Connaughton.
Why would they be arguing venue on an appeal? If anything were irrelevant in an appeal, I would think it would be the venue, because that's already been decided and determined by the lower court. And now we're talking about whether it's appropriate to have this case in New York.
No,
Jurisdiction's always relevant.
Yeah, jurisdiction is always relevant. So Dean got dismissed for lack of personal jurisdiction, which means no New York court can hold Dean, assuming we win, as a defamation liability. Let's say we win, we slam dunk it, we get a $10 million judgment. As to Newsweek, that would be okay because Newsweek is in New York. There's general personal jurisdiction as to Newsweek. You can sue them for anything about anything all the time. You can only sue someone for anything where they live. You can sometimes sue people for the transactions that they engage in other states or as pertains to other states. We could have sued Dean in Massachusetts, consistent with the due process clause, assuming that Massachusetts has, the full it's called long arm jurisdiction. Massachusetts allow people to be sued for as much as constitutionally they can be sued. Other states do things a little bit differently. They say we want to limit the number of suits that are happening here. That's what New York says. as specifically as pertains to defamation.
So specifically, oh, sorry.
Go ahead.
I was going to say jurisdiction is one of those really rare issues that could be raised at any point in any level of litigation. Jurisdiction is always at issue. So even if it's been established in a lower court, if something comes up in a higher court, they can always reopen that.
Yeah, to expand on this, theoretically, let's say the judge says, you know what, I think that I can exercise jurisdiction over Dean, and we get a judgment against her. And then obviously, she doesn't have anything in New York, so we want to go seize on her assets. We go seize on her assets in Washington. There's a statutory framework that we go file that judgment essentially in Washington. She has an opportunity to come in and say, actually, the New York court got it wrong. That's not a valid judgment as to me. And that's a procedural mechanism that can be done. You can't do it as to the merits of the case. Oh, well, so-and-so lied or what have you. You have to go to New York to fight about that. But she could actually assert, New York got it wrong. I'm not actually subject to suit here. And then you just have a whole nother wave of litigation over whether or not that judgment is valid as to her. So that's what this personal jurisdiction fight is all about. I respectfully disagree with Cameron in his analysis. I think the judge clearly got it wrong. I think that it's a full-time economic relationship is a business transaction within the meaning of the statute. And obviously, she wrote this article out of that business transaction. So all this business about, well, was it about a New York, what is the term? A New York resident? That's not what the cases say. The cases essentially say if she worked in conjunction with a New York resident, that's enough. If it's one of a series of letters, that's enough. She asked for money out of that letter. She didn't do that here, but that would be enough. The key case that we rely on was a single series of letters asking for donations and somehow, some way engaging in defamation in the course of that. In conjunction with New York residents is how it got published in New York. That was enough. So I think we win as a personal jurisdiction. My bigger concern is, do we get a trial or not? This procedural question of, well, if we affirm as to Newsweek, then what? We'll take it as it comes. Perhaps there's a saving statute in Washington if we want to go after her. But it's not res judicata. Res judicata is a notion that, well, it's already been litigated and the matter is closed. But whether or not I was going
to mention that, Matt, when he raised res judicata, I don't feel like that's the issue here whatsoever with the personal jurisdiction.
No, it's not. What he's saying is that if we refile in Washington, let's say, because the question posed is, let's say we affirm as to Newsweek, then what as to Dean? He says, well, they could file in Washington, but she would have a res judicata defense. To which I respond, no, there's a choice of law problem. Newsweek, assuming it's affirmed, was affirmed because we were held to the actual malice standard because of a New York statute. But since New York doesn't have any jurisdiction over her, she can't claim any protection under that New York statute. That's what
this shit is probably getting too nerd for the general listener.
Yeah, let's move on from the res judicatas and the collaterals.
Yeah, sorry.
Words with the offer to provide the receipts. It closed with an offer to gather more proof of sexual misconduct.
But why did the author have to choose that form of proof? Didn't she do a number of interviews? And she did a lot of follow-up. And it sounds like your argument is, in order to pursue this, she had to take advantage of that specific potential offer of proof.
She would have to take him up on a specific offer to look into facts about sexual abuse and cover-up.
But she looked into it, right? She just didn't
not
look into it by asking him for his, quote, receipts. She did interview other people, right?
She interviewed other people about other things. And
not
that was our
about
dispute.
cover-up of sexual misconduct?
Correct. She did not ask Joe Laycock, who we have a voluminous affidavit in the record about that. She did not ask Lucian Greaves, who we have all of his emails in the record about that. Scott Malthus mentioned it in an email, but no differently from Strange, he offers up accounts of some form of sexual abuse and cover-up. These are all hearsay claims that under the Butts decision, which I'll briefly take a moment to segue, that Butts did not assert actual malice because it predated the New York Times case that created actual malice, but Hart-Hanks, 591 U.S. at 692, expressly adopted Butts for purposes of determining actual malice and is the basis for our proposition that when there are obvious grounds for doubts, such as when, in the language of Hart Hanks, it is the nature of the charge is based wholly on an anonymous telephone call, that triggers a duty to investigate. And the failure to investigate, which is the core ground upon which we rely, is actual malice. And I also want to address this notion of potential departures of publication standards. These were not other people's standards that they departed from. These were Newsweek's own standards. It's the difference between the subjective test, which is recklessness, and an objective test, which is negligence. When I fail to follow my own standards, that's proof of recklessness. The district court discounted that at the outset of the decision.
So we have cases that stand for the proposition that not following sort of industry standards is not actual malice. You're saying because it was Newsweek's own standards, that does show actual malice. What's your best case for that proposition?
Regrettably, Your Honor, this appears to be an issue of first impression nationwide. I have searched high and low, and I cannot find any instances in which a publication failed to follow their own standards. Presumably, all those cases settled.
Why would there be a difference? I mean, why if you don't follow industry standards, is that not relevant to establishing actual malice? But following, I mean, maybe Newsweek's standards are based on some sort of national or industry standard or the like. But what's the logic of the distinction you're drawing?
The logic of the distinction is subjectivity. Recklessness is I'm aware of a risk of, in this case, falsity. Negligence is a reasonable person would be aware of the risk of falsity. So when my truth-seeking standards say I need to factually investigate a charge of criminality, as Cooper testified you needed to, that failure to follow that is proof that I recognized the risk of falsity and chose to not investigate.
So because Newsweek incorporated the standard you told us is required anyway into their own guidelines, that shifts it? That shifts the meaning of it? Outside of the cases referred to by Judge Nathan about industry standards and into a new area?
Correct.
So by adopting the industry-wide standard or a legal standard to its own guidelines, that's a publication runs that risk?
Yes. And that's not a bad thing. Newsweek gets to have more than 1 in 5 Americans read us in their own boasts because they have journalistic integrity. We're talking about one of the big 3 here. If National Enquirer had published this exact same claim, we probably wouldn't be here today because nobody would believe it if it was in the National Enquirer. It's because it was Newsweek that people believed it. It's because of those standards. It's because of that credibility that we are here today.
Thank you, counsel. All right.
Thank you for your time,
The
sir.
matter is submitted. We'll take it under advisement.
So that was the oral argument, top to bottom. What do you guys think?
Were you disappointed that the judge even asked you about her research into the article? When she asked those questions about, well, didn't she do a bunch of interviews? Didn't she talk to other people to try to get to the bottom of these claims? That disturbed me, and maybe it didn't disturb you because you know something more about appeals courts than me. But I felt it showed a lack of knowledge of the case to a greater degree than I would have thought. I thought the judges would have had more background on the case because I really did feel that was laboriously covered in the lower court. The fact that the journalist did not bother to follow up on any of this information, and even given those claims against us, she didn't even ask the other interview subjects about them.
I can interpret it one of 2 ways, either of which I don't mind. The first and more generous way is it's softball. The district court said, oh, but she talked to these other people about these other things, and therefore no actual malice. She was doing some kind of fact investigation.
Giving you the opportunity to put the fact on the record again that she didn't do that kind of research.
Well, more particularly to emphasize the point that no, she may have asked other people about other things, but when we're talking actual malice here, the question is whether or not they were reckless as to the truth of this particular charge. That's, you want to be nitty gritty about, well, which of these statements in the hit piece are false and defamatory. Well, the actual malice question attaches to each individual point of that. So it's not, did I have any actual malice as to anything, or maybe the inverse of it. Can I show that I had some interest in the truth as to any of the claims in my article statement? It's specific to the false and defamatory charge at issue. So that's the softball approach that could be. I don't mind it as a softball if that were the case. Alternatively, I can interpret it as she just didn't know the contents of the record, and I can't be mad at that. We were like fifth or sixth down the line in oral arguments. Each one of these appeals has, depending on the case, hundreds at a minimum, or sometimes north of 1,000 pages of material that these courts are expected to be, cognizant of, sufficient to ask intelligent questions on an oral argument. They can't really be expected to know every in and out of every single appeal. So, that doesn't really bother me because it gives me an opportunity to correct a potentially material misunderstanding.
Well, yeah, if that's something they didn't know, then it's a really good thing that it came up.
Very good.
Yeah, exactly. And here's my take on it is I think the whole negligence versus reckless thing, I'm honing in on that part because I think this does it does hinge partially on this. But basically what Matt's argument was, which I fully support, was, it's different. Negligence is you should have known better. Recklessness is you did know better and you didn't do it. And I think when it comes to an industry standard of an institution of this size, of this magnitude, of this publication, publishing something could be telling your neighbor. This is publishing it to the entire country or entire world, saying to not abide by your own journalistic standards to this magnitude of a readership absolutely is reckless. That is far beyond you should have known better. This is you did know better and you didn't do it. And I think what the judge was asking is, okay, fine, whatever. Is there precedent on that? Is there case law that says that line? And to which Matt had to say, no, on this particular issue, it's a case of first impression, which also says this is so outside the boundaries of journalistic integrity that's why there's not precedent. That's kind of how I took that.
So give me your read overall on how you feel the attitude of the court was, Stu. Do you feel you have any pulse on that?
Well, I feel like when you do an appellate argument, when you're the one appealing it, you've got this burden because they're going to look most favorable to the ruling of the lower court. You're going to get grilled. It doesn't matter what the issue is, high and low. When you bring that appeal, they're going to grill you and say, why should we reverse another court? They made a decision. They heard all the facts. They heard the evidence, the testimony. They saw the exhibits with their own eyes, whatever it might be. And you're saying they're wrong. So you've really got to bring it in an appeal. It's an uphill battle. So I think to get real grilled at appeal is just pretty standard. So to me, it's hard to give a take on how that, what the court's attitude is, as it's kind of standard for that kind of dialogue to happen where they're like, why should we overrule another judge? But I think it's a fascinating issue. And to me, from a personal level, from a layperson perspective, the thing that's so eerie about this entire topic is exactly what you said, where we don't have an incident, a time and place. There's nothing to show that anything actually happened. And this to me harkens back to the old 80s, satanic panic era with McMartin preschool. You have all these cases and you have all these guys like Geraldo Rivera saying, there's child sacrifice left and right. It's probably in your community. By their rumors, there's thousands of dead babies buried mysteriously across the country, yet no one can name one. Yet no one can say, oh, I lost my baby. Like, this is the same thing where there's some rumor by an aggrieved person who doesn't like us for whatever reason, doesn't even matter what his personal opinion is, but we know that, saying there's this rumor that's really harmful, that's really kind of gross, and they're just going to publish that. And I'm just like, wow, this really never stopped. This whole satanic panic era is alive and well. And that's why I think lawsuits like this are so important, where we have to push back on this, because it's going to happen forever. This whole, by virtue of who we are, there's going to be these rumors. And it just seems like there has got to be a stop to this. And hopefully it's judicial, where they say, you can't be doing this stuff. You can't be spreading this harmful information that puts people, frankly, in danger based on conjecture and rumors from the highest level, a publication that's read nationwide and internationally. And to me, again, as a layperson, not even as an attorney, hearing that, I'm like, yeah, that's absolutely reckless. That's a reckless disregard of the truth.
Yeah, well, to the point of satanic panic, it's published by, like I said, this unhinged Christian, maybe Catholic writer who teamed up with people who call themselves Satanists who are making these claims against us, but in the Newsweek piece, admit that they're not Satanists or don't identify as such and never did, but they thought the activism was cool. So I don't know. It feels like malice all the way around.
It does feel like malice to me too. Yeah, I really hope we prevail. Even if it's just on that statement, I would be very pleased with that because it is harmful. There's a lot of people in this organization. There's a lot of good-natured people. They can't point to a single incident. This is just perpetuating stereotype and bias against the minority religion, which is the exact thing that we've been fighting about from the beginning.
Stu, I don't know if you're aware of this, but the reporter actually does have Satanic Panic era articles.
I did not know that.
Yeah,
So,
that was part of our. I didn't talk about bias on the oral argument, but
right.
part of our argument is, look, it's not just that there are obvious grounds for doubt. It's not just that their own editorial standards said you got to investigate this and they didn't do one, but there's demonstrable prejudice by this chick. And even the
Yeah.
judge,
Yeah.
oh yeah, there's prejudice. Yeah, there's bias. Okay, but bias alone isn't enough, which was part of my, there are other things like that, which is partly why I was like, look, you can't just when actual malice is solely proven through circumstantial evidence, that's the only way that you can prove actual malice. When you're discounting inferential grounds, you're picking and choosing which one's enough by itself. Nothing's ever going to be good enough. That's
Right.
the
That's exactly true. And also, I mean, as another point, this is exactly why hearsay isn't permitted at any level in criminal cases without specific exceptions because of this. This is exactly why.
We'll see what we get. I would assume we'll get a ruling within 3 months here. That's just my impression. Um, who knows? Maybe not. Maybe they'll take forever. We're still waiting on the Baphomet case in Arkansas after all. But I suspect that next time we do a legal update, I guess this is a game we should play at the end of the legal updates. What do you think the big issue will be by our next legal update? You think it'll be Iowa?
It'll very likely be Iowa, depending on.
Well, I'm looking
depending on
forward to
when we
Iowa.
get. Iowa's, without making any promises, that's proceeding toward court as to what timing is that going to be and whatnot about that. That'll be for the next one.
Yeah, and there's a lot of interesting things about that one. But
Hey, speaking of this, I wanted to give a quick shout out. I was just looking at the date, and this week, I believe, is the 10-year anniversary of the Arizona chapter. It was in February of 2016 that Michelle Short and I co-founded the Arizona chapter. So I hope they're partying. I hope you all had a good Lupercalia. And I've seen some stuff from the Arizona chapter. I'm glad those of you there are keeping that torch going. So happy anniversary to the Arizona chapter.
yeah, very good. Happy anniversary to them, and congratulations to you, Stu.
Thanks,
Well,
guys.
thank you guys. Yeah. Until next time, good night.
Bye.